everyone, welcome again to Yuhu Education Sessions. My name is Isela Ayala. I am the managing attorney of JM Law Office. In this video, we're going to talk about a recent decision from 2024 of the Second Circuit deciding issues on copyright infringement and the selection and arrangement doctrine in the context of music. Remember that the content of this video is not legal counsel. If you have a question, you can leave it on the comments. We'll do our best to answer that question. Or if you want to resolve a situation regarding copyright, you can reach out our office and we'll be more than happy to help you. With that said, I'm going to start. So today we're reviewing a decision by the Second Circuit that decides an appeal against a summary judgment motion. What does that mean? A summary judgment motion considers the facts of the case, and if there is no dispute as to those facts, the court will apply the law and decide the controversy. A summary judgment motion requires important fact finding and is usually filed after a good amount of discovery when the party that is requesting summary judgment has enough elements of fact to show to the court that there are no factual disputes. Therefore, as a matter of law, applying only legal principles, they can have a judgment on their favor. In the case of Ed Sheeran, the litigation was concerning copyright interest in the song Let's Get It Out, a song written by Marvin Gaye in 1973 and also registered in 1973 prior to the enactment of the 1976 Copyright Act. Now, for purposes of this litigation, it's also important to know that this litigation, which started in 2018, was commenced after a prior litigation. So I'm going to take a step forward and explain to you some important facts. For that purpose, so in this litigation, the first one in 2017, Griffin, McDonald, and the state of Cherryville Town filed a lawsuit against Ed Sheeran, Amy Wage, and other parties responsible for recording, distributing, and licensing Thinking Out Loud. Now, in this litigation, Structured Asset Sales, another joint owner in the copyright in Let's Get It Out, was not able to join. They filed a motion to be part of that litigation, but the court denied. And the court said that this will not be in detriment of the parties, and the proceedings were too advanced for that. So as a result of that, two litigations were ongoing at the same time. In the 2017 litigation, the case proceeded to trial, and the Ed Sheeran team and the plaintiff's team argued their case before a jury, who finally decided the case in favor of Ed Sheeran. And the issue was one, whether there was copyright infringement, and two, specifically, whether the songs were substantially similar. For purposes of doing this analysis, the courts consider the scope of protection for the two works and also the applicable laws or statutes or principles that will be considered, considering that the song was written and registered before the enactment of the 1976 Copyright Act. So let's review what were the issues and what were the works that were here being compared. Okay, so in 2014, Ed Sheeran and Amy Wage wrote Thinking Out Loud, and this became a hit in the UK and around the world. So this song gained global recognition and it acquired about 3.8 billion streams on YouTube and 2.5 billion on Spotify. Actually, on the 58th Grammy Award in 2016, it won Song of the Year and Best Pop Solo Performance and earned a Record of the Year nomination. On the other hand, we have Let's Get It On. Let's Get It On was a song written by Marvin Gaye in 1973. And at the time, 41 years earlier, the song was also one of the biggest hits of Motown. Now, the song was registered before the Copyright Office right after being written and recorded. But what is important is that registered before the US Copyright Office was the music sheet, 5 pages of the music sheet containing the song's melody, harmony, and some rhythm. and the lyrics. Now, it is important to remember that this registration happened before the 1976 Copyright Act. So, at the time the song was registered, the applicable law was the Copyright Act of 1909. And under the scope of this law, the protection for musical composition was limited to the copy deposited with the U.S. Copyright Office. So, for purposes of protection, sound recordings were not considered, and accordingly, the elements and the scope of the claims of this litigation were limited to what the court called the four corners of the deposit music sheet before the U.S. Copyright Office. What's the difference with the current law? So, under the 1976 Copyright Act, there were many differences, and the protection of music compositions and music in general was broadened. So the 1976 Copyright Act considered also sound recordings and broadened the protection, allowing the parties even to deposit with the U.S. Copyright Office a copy of the sound recording. But what is also important to understand is that the 1976 protections did not retroactively alter or apply to the scope of protection granted to works registered under the prior law, the 1909 Copyright Act. And what the court said is we must apply the Copyright Act of 1909 because that's what is the principle in copyright, that one must apply for purposes of copyright infringement analysis the legal framework in place at the time the song or the copyright protected work was registered. That is the applicable law. Now, in this litigation, that, like I said, happened like in two cases at the same time, the second litigation that we are discussing today involving SAS, as we are going to call it from now on, right? The structured assets sales. The plaintiff argued that this was the wrong analysis, that the court should have considered also the sound recording and the rhythm and the baseline of this recording because that could be inferred from the music sheet. And that's something that was important because experts for both parties offer their analysis. However, the court limited the scope of evidentiary record for purposes of the litigation. So on the second litigation, the one we are discussing today and the one that is reflected in the decision issued by the Second Circuit, Sheeran filed a motion for summary judgment. The court first defined what was the scope of the claim, and basically the court said we will only look at the four corners of the music sheet deposit before the U.S. Copyright Office. So considering that limitation of what was going to be the scope of the copyright infringement claim, the Sheeran team filed a motion for summary judgment. And what the Sheeran team said is that the core progression that was that has been the focus of the plaintiffs in this litigation is not original enough. And on the selection and arrangement doctrine, I will explain it next, this is enough to conclude that there was not copyright infringement. So on that first motion, the court defined the scope of evidentiary record and decided the motion, what is called motion in limine, basically only resolving pre-trial issues regarding evidence. And the court basically said that the plaintiff, SAS, could not offer evidence related to the sound recording because the sound recording was never deposited with the U.S. Copyright Office. At some point, SAS also implied that they might actually register the sound recording and amend their complaint. The court said that the court would probably be inclined to separate the two litigations because the analysis was different. However, at the end, SAS never registered the sound recording for the song before the U.S. Copyright Office and never started another litigation. Now, Regarding the experts and the offering of evidence outside of the scope of the music sheet deposit with the Copyright Office, basically the court wanted to be clear, and I'm going to read how the court expressed this idea. There is no genuine question that there is no notation or specification of a bass line on the deposit copy that has been accepted by both sides and it's apparent from visual inspection, it's beyond dispute. So the plaintiffs wanted to argue that the core progression of Let's Get It On song and the anticipation, the harmonic rhythm of the song were substantially similar to the Thinking Out Loud song. And to do that, they will have to compare the sound recordings. Now, they couldn't offer the sound recordings, but they had this expert who actually explained that the bass line and this harmonic rhythm that the plaintiffs were referring to was the most common, that any musician who saw the music sheet and who looked to those notes would have played the song in that manner because it was the customary, considering how the music was written in that music sheet. And specifically, the expert for the plaintiff said that the most direct and basic practice is for the baseline to be formed from the roots of each chord specified in the deposited copy. Since the chord specified are, and he mentioned this, E.G. minor, the most obvious baseline is simply a succession of notes. So the expert wanted to explain that even though we would only have the music sheet, from this music sheet, you could infer how the song would be played, and that was obvious to anyone looking at it. However, there was a note by the court explaining that even if that was true, if it was so obvious how the song would sound, then there might not be even be an issue of originality. That's not really original. That's how it works with those chord progressions or notes highlighted by the plaintiff. After defining the scope of the claims, only the music sheet, Ed Sheeran again renewed their motion for summary judgment, arguing that the combination of those notes, those chord progression, was not original enough, and therefore they were entitled to a decision on their favor. That's the point that the court of the Second Circuit makes regarding the selection and arrangement doctrine. But before we explain that, I'm going to explain what happened next in this litigation. So the litigation started. There was a first motion for summary judgment. The only step by the court was defining the scope of the claim. Next, Ed Sheeran renews the summary judgment and it's denied. The court said that even that might be true, deciding whether that combination it's creative enough if it's a factual question and must be decided at trial. In the meantime, the other litigation, the one involving Griffin and the other joint copyright owners of Let's Get It On, continue. And on May 3rd of 2023, a decision was issued by the jury. As I told you, there was a judgment in favor of Ed Sheeran. 12 days later, after this decision in Griffin versus Ed Sheeran, the court accepted a motion for reconsideration by Ed Sheeran and reevaluated its analysis of the facts of the case. And basically, the court said that the court had overlooked an issue that is very important and that has been developed by the Second Circuit regarding a numerosity requirement in the selection and arrangement doctrine. Basically, after reconsideration, the court decided, yes, I'm going to approve this motion for summary judgment, and there was no infringement by Ed Sheeran. And the decision is appealed. And this is when we find ourselves with a decision that really breaks down the issues and analyzes whether or not there was an error by the court in deciding this motion for summary judgment on in favor of Ed Sheeran. So basically, the court considered two issues. One, the applicable law on the scope of protection for Let's Get It On. the song written 41 years before, and two, the applicability of the selection and arrangement doctrine. So, regarding the scope of protection, the court said that there was no doubt that the song had been registered in 1909, where there was only protection for a music piece, a music composition, as it had been deposited with the Copyright Office. So basically, the court explained that the Copyright Act of 1909 provided for protection of musical compositions when they were published or unpublished. However, the treatment was different in each case. The court explained that a composer could seek protection for unpublished musical composition by depositing a copy of that musical composition, a complete copy of that musical composition with the Copyright Office. That was one option if the work was unpublished. The other option was to protect a published work, but publication required putting that work out in the world with a copyright notice. This copyright notice, it's the C inside a circle. And that copyright notice should be attached to each copy of a published work. Now, the court reasoned that in the case of a sound recording, there's no really way to publish that piece of a creative work because the transmission by the air, or by sound, or by radio of the song, even if you are saying that it is protected by copyright, it's not a publication under the statute that applied before the 1976. Under the Copyright Act of 1909, transmission by radio of a musical composition was not publication. Therefore, a music composer had to proceed to registration by depositing a complete copy of the composition with the Copyright Office. So basically, the court explained that if an author of a published work failed to comply with the deposit requirement, his rights under the Act 1909 were actually unenforceable. Thus, in order to secure a copyright act on a musical work, whether published or not, depositing a copy of that composition was required. And that deposit will be the only complete work. So looking at the sound recording will basically mean that we were not being coherent with this definition of complete. And complete, it's only what was deposited with the Copyright Office. Now, the other explanation for this is that the court considered that the deposit of the copy with the Copyright Office allows the interested parties to know what is actually being protected. And that allows a party who is creating something to really know if they are infringing on someone else's work. How? Knowing exactly what is protected. And if we look the statute in a different way, the copyright law could be protecting works that are unregistered. Why? Because they might be unpublished, and if they have never been deposited with the Copyright Office, how anyone could know what's protected. Now, the court also then applied these principles to the case and explained that the only thing that was deposited with the Copyright Office were these 5 pages of the music sheet, and no notations or no additional comments were made regarding the way the music will be performed or specific arrangements. Therefore, the district court was correct in limiting the scope of the claims only to the 4 corners of that musical composition as deposited with the Copyright Office in 1973. Now, the second part of the analysis was the selection and arrangement doctrine. And the case explained that when it comes to copyright, there are protectable and unprotectable elements in a work. For example, functional or necessary elements to create something are unprotectable elements. Factual elements are also unprotectable. They are not original. Now, a work that contains unprotectable elements is still protectable under copyright law. And this is where the selection and arrangement doctrine started to be relevant. So the court first explained, to establish copyright infringement, one must define one, if a work is protectable, of course, and two, if there's been copy. Now, proving copy is one of the most challenging parts of the analysis because it's really rare to find direct evidence of copying. As a result of that, when we look at other issues, instead of looking at direct copying, we will analyze if the defendant had access to the original work, and two, if between the two works there is substantial similarity. Now, to determine that substantial similarity, we need to understand what the work is, right? And also we need to understand that the standard test to determine substantial similarity is if an ordinary observer, not an expert, any ordinary observer, unless looking for differences, would be disposed to overlook those differences and regard two works as aesthetically equal. This means also that an average lay observer would recognize one work as the copy of another, could not make a differentiation between them. And as part of that analysis, the court then talked about these protectable elements. And the court said that only those elements that are original, there are no functional, there are no factual, are the ones that must be the core of the analysis, and these original elements must be independently created. So when we look at two works, we're going to look to understand their protectable elements and make a conclusion whether from their protectable elements perspective, they are substantially similar or not. Now, considering that the plaintiff was focused on four chords, the combination of them, and some harmonic rhythm applied to the reproduction of the song, the court said that, well, are these chords original or commonplace? And the court considered that these chords making the music sheet of Let's Get It Out are commonplace building blocks for music, specifically for pop music. And as a result of that, being so common, the number of possible combinations is limited. Now, when it comes to applying the selection and arrangement doctrine, what we want to protect is not those not protectable elements, but what the court says is that if that arrangement, coordination, selection of not protectable elements, it's original, that result is protectable. The court said in this case, those four chords, which are basic notes to create pop songs, is so limited the amount of possibilities that Let's Get It On combination is not original enough to be entitled to protection under copyright law. This is important, and it's important also to consider that the court did not allow evidence regarding the sound recordings. When you listen to the songs, I'm going to leave the links on the comments section. You can judge by yourself if they are similar or not. However, it's commonly understood in the industry that these four chords have limited combinations and they have been used in many songs in the pop industry. The court actually said that the limited number of notes and chords available to composers and these results, it's so that there is no possibility to find that this combination was original. That's why they are common building blocks. So the court also considered that Sheeran provided evidence that the combination of these chords had actually been used in the past to create other songs that actually were written prior to Let's Get It On. And with this analysis, the court finally concluded that the district court decision was correct, that there was not wrongful application of the law. And I'm going to again summarize the argument. So the court considered first, what is copyright infringement? Copyright infringement, it's the act of copying or the evidence of indirect copy. And when we think about indirect copy, we think about the characteristics of the work, the elements of the work, what elements are protectable and what elements are not protectable. And we also going to look the substantial similarity between the works. But in order to make that analysis of substantial similarity, we must be focused on those original, creative, protectable elements under copyright law. A work that has non-protectable elements can be protected if the arrangement, selection, and coordination of those elements is original. However, in this case, the conclusion was that Let's Get It On combination of elements was not original enough, and therefore the district court was correct when they decided in favor of Ed Sheeran this motion for summary judgment. So here it's also important to consider that the court looked at the melody and the arrangement of both songs and made the comment that no reasonable jury, considering the protectable elements of each work, will find them substantially similar. So basically, the court said there might be similar, but the similarities are related to non-protectable elements because that selection and arrangement is not original enough. The possibilities when it comes to the combination of these notes is too limited to be entitled to protection. And specifically, the court referred to the chords 4, 5, E minor, among others. Now, this case is relevant because it shows how in the music industry, the threshold, even though we have said many times that the threshold of originality for purposes of copyright protection is low, this decision illustrates that it's not that low when it comes to music, that there are common building blocks that are usually or commonly used to create pop songs. So the threshold of originality to make something protectable is high. Usually the course will be focused on arrangements, melody, and lyrics for purposes of concluding whether two songs are substantially similar or not. The presentation accompanying this video, which explains in further details the decision of the Second Circuit in this case, it's in the comments. You can check that. And if you have any questions, please let me know. I will be more than happy to answer them. I hope you enjoyed this explanation regarding the case of Ed Sheeran and this charge of copyright infringement, which at the end resulted in a favorable decision for Ed Sheeran and the protection of thinking out loud. My name is Gisela Ayala, and I will see you in the next video. Bye bye.